Good evening, everyone, and welcome to another edition of our Justice and Peace's guest speaker series as we continue to talk with paralegal and lawyer bencher candidates about the upcoming election. As always, the views and opinions are of the candidates alone. They don't reflect me, Justice and Peace's Trials College, or any other education institution or organization that I'm affiliated with. Wrapping up this evening, we have Johnny joining us here today. Johnny, maybe you can start by telling us a little bit more about yourself.
Sure. First of all, JP, I want to thank you for doing this. I know what a commitment you've done. So my real name is Jonathan Rosenthal. I'm a criminal lawyer and I'm a sole practitioner. I was called to the bar in 1989, but for a few months, I've always been a sole practitioner. And I know what it's like to be a sole practitioner and the challenges that we face, the unique challenges. And unless you're a sole practitioner, I don't think you can really understand those. So I always bring that sort of thought process to the table. As you know, JP, I also do a great deal of teaching in trial advocacy and criminal law, both in Toronto, the United States, Alberta. I used to teach in New Brunswick. I teach civil lawyers, criminal defense lawyers, Crown attorneys, paralegal students, law students, and on occasion, even judges. I was first elected to bencher in 2015, and I ran because the former criminal lawyers that were benchers, who were Alan Gold and Mark Sandler, were timed out. And I thought it was very important that criminal lawyers have a seat at the table. Now, I certainly do not or did not put myself in the same league of those two. But a couple of people put me up and thought that I could get elected, as I had taught trial advocacy for such a long time. And as I said, a lot of my teaching is to all different sorts of lawyers. I had no backing. I had no donations or no one funding my campaign. I ran entirely on my own, and I ran on my reputation. And I ran, as I say, a very lean email campaign. I phoned just about everyone I knew, and I emailed just about everyone I knew, and I was successful. And becoming a bencher, I quickly realized the incredible responsibility to the profession that a bencher has to govern in the public interest. And proper governance in the public interest is key to self-regulation. And self-regulation is key to an independent bar. In 2019, when the Stop-SOP ran, I was initially not elected. I came in one spot out of getting a seat. I was called up a few months later when one bencher resigned as a result of a government appointment he took.
So what brings you back for, looking for a third term here, or years 9 to 12 as a bencher? Why are you running again?
Because JP, I really care about the profession. I'm one of those people who is truly proud to say I'm a lawyer. To me, it's not just a job or a business or a way to make a living. It's a profession, and I love our profession. I think it's an honorable profession. I think it's a noble profession. And that's why I spend so much of my time teaching and mentoring. And I'm terribly concerned about the future of the Law Society and the future of the profession and the self-governance of our profession. Self-governance is not the norm, it's the exception. And to be very frank, one of the reasons I'm running is to make sure the full stop does not get elected. They are the greatest risk to self-governance, and that is the full stop. I've witnessed firsthand the behavior of many of the full stop bencher incumbents at convocation. As I say, there is no doubt in my mind that self-regulation will end if they get elected and get the majority of the seats. I have watched their conduct. They have brought irresponsible motions. To highlight just a few, they brought a motion to drastically reduce fees by 25% with no consideration of the consequences of the cuts that would have to be made with that reduction. They brought a motion to have only benchers call the names of those being called to the bar, as opposed to a professional name caller. Slate benchers thought they were entitled to call the names. Calls to the bar are such a great event. I love attending those events. I know how important it is to those being called. I teach 4 full-time courses at Osgoode Hall or Osgoode Hall Professional Development. I know the students, and I know it is one of the most important days in their lives. Nothing to me is greater when you hear the whoops and the shouts from up in the rafters of Roy Thompson halls. Benchers used to call the names. I used to get to call the names. To be very honest, I hated it. It was stressful. There was a website which gave you, how to properly pronounce a name, and often we didn't get it right, or I didn't get it right. Some Slate members basically said, suck it up. It's part of being Canadian to have your name mispronounced. Really, it's such a small step to make the day, which is the new calls day. It's not the benchers' day. It is their day. Their friends are there. Their family is there. They brought a motion to allow all benchers to attend the Proceeding Authorization Committee, which I chair, despite the fact that this would be in violation of law society bylaws, which restrict attendance to only those people on the committee to attend. That's a committee that authorizes conduct, proceedings, interlocutory suspensions, deals with highly personal and highly confidential information. This was part of an omnibus motion they brought, but they didn't recognize the consequences if that motion was passed. They brought a motion to abolish the bencher code of conduct. Almost all boards have codes of conduct. As lawyers and paralegals, there's rules of professional conduct. And I would just question, why would some incumbent full-stop benchers think that they should not be bound by a code of conduct like the rest of us? I've witnessed firsthand, JP, many of the full-stop bencher incumbents treat law society staff right up to the CEO and the CFO with utter contempt. 2 incumbent benchers disclosed confidential materials. One actually tweeted, which I've got to say is probably a law society first, a confidential motion. I'm also very concerned about the way some of them are conducting themselves in this election. I'm not going to name names, but one incumbent member of the Full Stop changed his address to an auto body shop owned by his father, and the phone numbers he had to 416 numbers the day nominations closed so he could run in Toronto as part of the Full Stop. And that's because the Full Stop simply couldn't find 20 people in all of Toronto to join their slate. And it's interesting, in his first post on the Full Stop website, he said he was a lawyer outside of Toronto. Now, this was a new page. It talked about his work as a bencher. So I question, who else on the slate knew that this was going on? To me, that is not something any lawyer should be doing, let alone a bencher. And one of the 416 phone numbers he used was the former fax number of another Full Stop bencher. Several of the Full Stop benchers candidates are still affiliated with the Justice Center of Constitutional Freedoms. So we know that is the organization whose president admitted he hired private investigators to investigate and surveil the very judge they were appearing in front of. Now, they don't want to be openly affiliated. Why? Because everyone knows that is not good conduct. That is not proper behavior for any lawyer, any paralegal. I won't ask you what you would say to one of your students, but I could tell you of one of my students or a young lawyer approached me and told them that their boss admitted to hiring private investigators to surveil a judge. I would have 3 words: run, don't walk. But they don't want to be openly affiliated because they know that. So they've taken their names off the Justice Center of Constitutional Freedom's website. Two of them have also changed their addresses to Toronto addresses. But in the last 30 weeks, two of them recorded YouTube videos soliciting funds for the Justice Center of Constitutional Freedoms. I get it. If something happens, you may not want to give up files right away. You don't want to put your clients at risk. But the Justice Center of Constitutional Freedoms is not a client whose interests would be put at risk. They're raising funds. They're acting on matters for the JCCF. I think that's wrong. Is that who we want running our profession? So that is in part why I'm running as a bencher and seeking a third term. To me, bencher has always been a hard work. You put in a lot of time. I would guess I put in about 60 days a year to being a bencher.
Now, Johnny, I guess that brings sort of the reason there, right, that you brought up is, well, there was the Stop group, right? 22, I think, of them the last time they got elected. And now you have, as you're a part of the Good Governance Coalition, I think 40 lawyers and 5 paralegal candidates that are running together. But, it kind of comes across to some, as being kind of hypocritical that, hey, we're condemning this one group of slate. However, we're running together. And then if we're elected, we're going to look at abolishing perhaps slates altogether, or electoral reform can be investigated. It requires certainly a leap of faith that this is all going to happen. So what would you say in response to that kind of criticism that, are you a slate or are you a coalition? And it's kind of like the meme online. You have the Spider-Man sort of pointing at each other. What is it, and how would you respond to that criticism?
That's a very fair question, JP. And the bottom line is the Stop group, now the Full Stop group, swept the election last time by vote splitting. They didn't get the overall majority of the votes, not even close. They got a big chunk, and the rest of the votes were split amongst many candidates. And we can't see that happen again, because if it does happen again, self-regulation will end. Now, just remember, anyone who put their name down in 2019 and again this year became part of the slate, and they became a bencher with no consideration to what abilities they had for this incredibly important job. The Law Society website used to say benchers are the leading members of the bar. So we had benchers that part of the Stop, they never really practiced, or they were retired. Luckily, last time, only 22 people signed up. If we do not run as a coalition, I fear that would happen again. And I care too much about the profession to allow self-governance to end. There is no self-governance in England. There's no self-governance in the United States. It's a rarity. So we had no choice. If we didn't run as a coalition, the Full Stop would likely sweep this election. Now, many of people agree with us. And just yesterday, I'm not sure if you've seen this, JP, 20 past presidents of the advocate societies, luminaries of the legal world, Marie Hennon, Linda Rothstein, Guy Pratt, I can't name them all. This is what they said. This year's bencher election matters. Our ability to self-regulate is at risk. I'm not sure if you saw today that 8 former treasurers of the Law Society, these I can name, Tom Conway, Teresa Donnelly, Lee Ferrier, Vern Krishna, Derry Miller, Lori Palizzo, Alan Rock, Harvey Strasberg endorsed us. And they said the same thing. We are worried about the future of the Law Society and of the legal profession's ability to retain the privilege of self-governance. The key to the future lies in the choices made by the current bencher election. So the view of why the coalition is necessary is shared by many. I invite your viewers to go to our website and see all of the organizations that have endorsed us. So that is why we are running. As I said, first time I ran alone. Second time, I think I might have done a joint mailing with some other folks. I understand that I have an independent fiduciary duty as a board member, regardless of I'm part of a coalition or not. And I will respect my independent fiduciary duty throughout. And I can assure you of that. I'd love to see if there is a way to get rid of coalitions. I don't know the answer to that. But if there's a way, I'm all for it. So why did we do it? We did it to protect self-regulation. We did it to protect the independence of the bar.
Now, in perhaps in response to that, I mean, certainly, you have the Full Stop team, right? That they're messaging about, the law study has lost its ways, stop bloat, stop creep, stop woke, and even to all of those endorsements that you pointed out, kind of like, well, it's the establishment supporting the establishment, right? So how would you kind of respond to their messaging and what's come up and why you're saying that this group is a danger to self-regulation?
Well, that's a long question. The establishment, I'm a sole practitioner, criminal lawyer in Toronto. The establishment, Jacqueline Horvath, the treasurer and a member of the Good Governance Coalition, is the daughter of an auto worker. The slate has demonstrated throughout their conduct I talked about what would happen if they win. It's simply untrue bloat. And, like they talk about fees, and they talked about cutting fees by 25%. Well, if you cut fees by 25%, you have to spend 25%. Now let's talk just briefly. I thought of an example, the mayoral election. I'm sure in this mayoral election, someone's going to say they're going to cut realty taxes by 10%, 20%, 30%, 40%, 50%. I get it. It sounds attractive, especially in these harsh economic times when people are suffering, mortgage rates are going up. But if you cut realty taxes by any percentage, you have to say, what services are going to be cut? What's the other side of that equation? Are we going to cut repairing roads? Are we going to cut garbage collection? Are we going to cut the fire department? Are we going to cut schools? Or are we going to shut down the libraries? And so they talk about these cuts, but not once has any member of the Full Stop ever suggested what service that the Law Society provides they would cut. They've complained now for 4 years, but not once have they come up with one single suggestion of what they would cut. They said, let's cut it by 25% or let's cut it by 10%. Those are random numbers. One said, the closest they got, and I know we always talk about in trial advocacy, JP, facts, not conclusions. The closest they got to a fact, one said, let's cut money from professional regulation. Well, not particularly, just let's cut it. Well, sorry, we are in the professional regulation business. So I get it. It's a real crowd pleaser, but they have no idea what they're going to cut. Why? Because we are not overspending. We are not bloat. The law side fees are in line with every regulator of lawyers in Canada. Now, I know they make comparisons to the United States. Well, let's just remember, lawyers in the United States are not self-regulated. Discipline is ordinarily done by state prosecutors. They compare it to the College of Physicians. Now, there's a few points. Sure, we have more staff than the CPSO, but we have more members. In fact, they have more staff per members than we do. They talk about dues. Yes, a lawyer's dues are more than a doctor's dues, but they're different regulators. And I'm just going to give you one example. At the CPSO, they had 37 files in discipline. We had just under 200. Our investigations are complex. Why? We are regulating a profession that has cumulatively billions of dollars of people's monies in their trust accounts. We're entrusted with that money. They're complicated investigations often. They're usually, if almost always, done with lawyers or the involvement of lawyers. There's complicated forensic investigations. Why do we have to do this, JP? Because we need to protect the public. Why? Because if we don't properly protect the public interest, which is what the benchers are statute bound to govern by, we will lose that self-regulation. We have a compensation fund. Sadly, we have lawyers who steal money from people. And when that happens, we have to make those people good to some degree. Look at a doctor's file. Their investigation, if there's someone, a doctor's alleged to have, generally speaking, engaged in professional misconduct, another doctor looks at the file and gives an expert opinion. Those aren't our investigations. They're complex, they're expensive, and that's what you have to do a proper regulatory body. Now, they talk about woke, and I've got to tell you, I don't really understand what people mean by that. I've got to say, for the first time in my life, several members of the slate have shouted that at me. Now, it's clear no one on the Good Governance Coalition has any intention of bringing back the statement of principles. But that does not mean that I am not cognizant of issues involving equity and diversity and inclusion. If my recognition of those issues means I'm woke, go ahead, call me woke. I recognize that systemic racism exists in the justice system. Former Chief Justice Strathy said it. The Supreme Court of Canada has said it. Just last week, my dear friend, Minister Mendocino, said it. If saying it exists and wanting to do something about it makes me woke, go ahead, call me woke. And, and I was thinking about it today. I've never suffered racism in the justice system. Why? I'm a middle-aged. Don't laugh and call me old, JP. I'm middle-aged. I'm a middle-aged male. I just want to tell you one story. When you're elected a bencher, you get an ID card. I thought it, kind of replaced my Law Society card. It's actually a key pass. It had my picture on it. And I had it at the front of my wallet because for many years before COVID, was going into courts every single day of the week or going into the Law Society every single day of the week. And I would flash this out just quickly as I walked into a courthouse. I was in court out of town. I was trying to think of where it was. And one of the security guards said to me, "Mr. Rosenthal, could I speak to you for a minute?" I had no idea how he knew my name. And he quickly asked me if I didn't remember him from his days at the Law Society. I confessed I didn't. He asked me to take my ID out of my wallet and pointed out to me that my ID had neither my name on it nor the Law Society on it. It only had my picture. And I compared that experience with what happened to now Justice Lori-Ann Thomas when she talked about what she went through in going into a courtroom. One day at the Law Society, now Justice Sandra Nishikawa, when she was a bencher, a bunch of us were walking by and the security guard stopped her and asked her for ID. So again, if it bothers me that happens to people, call me woke. If someone thinks that me going back and engaging in a discussion with the security guard about why he singled out the one non-white bencher to ask for ID, call me woke. Because I don't really know what that means. But what I do know is there are issues in our criminal justice system with systemic racism. And there's very few people who deny the existence of that. There's very few people who don't read cases from the Supreme Court of Canada where they say it exists. For crying out loud, the Peel Regional Police Force, they admit that there's systemic racism in the justice system. So that's what I say to bloke woke.
Now, I guess the next piece there then is, well, what are the things there if you're elected and if maybe the Good Governance Coalition are elected, in terms of the next 4 years, what are some of the things that the Law Society should be doing in terms of within their mandate? What would you like to see being done or continue to be done going forward?
Well, I think we've got to get back to good governance. And I say that as humbly as I can, having witnessed what has gone on in the last 4 years. Benchers are public interest regulators. We're not, a debating society where we get up and we yell and we shout. That's not what it's about. I have personal things that I'm very focused on that I'd like to see get done. For example, to me, CPD is incredibly important. All lawyers should continue to learn, but I would like to see the expansion so that all sorts of CPD can be obtained by engaging even more activities. I want the law side to recognize pro bono work. For years, I've been engaged in pro bono work, both in my practice. I do counsel work for an organization called Beyond Borders. I do it because I'm passionate about it and the benefits to me are immense. And I would encourage all lawyers who can to do it. It should not be a mandatory requirement, but I would like to see some recognition from our regulator to support a model that those who do the work do receive some benefit, whether it's fulfillment of CPD, rebates on law pro dues, or something along those lines. Access to justice is something that is dear and near to me, and I think we're in a very unique opportunity coming out of COVID. The most valuable resource in the criminal justice system is our court time, and especially in criminal cases where cases have to be heard within either 18 or 30 months, or they're likely to be stayed. And anyone who regularly appears in court knows that there's just too many litigants who can't afford a lawyer. When you've got the poverty rate above the legal aid cutoff rate, we've got a problem. I've been on ASLA for the last several years at the Law Society. The loss, I must continue to engage with all levels of government for better legal aid funding, working with the courts to help address the needs and how lawyers can assist self-represented litigants. I hope that all levels of government will finally realize it's simply cheaper to the system as a whole to provide parties with lawyers than to allow individuals to be self-represented. The certificate, I'm very supportive of the clinics, but the certificate system is key to a strong independent bar. Many people are facing criminal accusations, are suffering from mental health issues. You can't simply appoint a lawyer for them. They need the choice. The family law service provider license should not be expanded. It will not solve the problem of too many litigants and self-represented people in family law. It should help people who don't have a lawyer navigate the system. And again, we need legal aid for family law. I can tell you, I drafted a minority report to convocation when a much more broader scope was proposed. I did that in conjunction with leading members of the family law bar. And the model that was eventually passed by convocation was identical to the proposal that I had suggested. I really want young lawyers to take a much more active role in the regulation of our profession. The young lawyers of today are the leaders of the bar tomorrow. Young graduates or new calls, they are suffering from different sorts of pressures than I am. I'm not going to try to age you, JP. The law say must continue to support young lawyers and young members as much as they can. Their voices must be heard at convocation. I would strongly support a dedicated position for a new member of the bar at convocation. I know many young graduates cannot find articling jobs. Not paying them, in my opinion, is disgraceful, would not solve the problem. I strongly supported at convocation the law practice program. I strongly support integrated practice curriculums, IPC. I've supported those in convocation and in my teaching. We need to do whatever we can, and when I come back to young lawyers, I know that's on your topic list, to encourage the mentoring of young lawyers. When I was the vice president of the Criminal Lawyers Association, we set up a mentorship program. Mentoring is so important to newly minted lawyers. Discipline. I've now been on the Proceedings Authorization Committee since 2015, presently the chair. I believe the former discipline process, that's hearings, should be reserved for cases in which the public is put at risk or the conduct complains of brings our profession into disrepute. Members who lie, cheat, and steal should be dealt with expeditiously to ensure the protection of the public and to ensure the good name of lawyers. Matters that don't involve that sort of conduct, there should be alternatives, alternative dispute resolution, mentoring, restorative justice. It's being used more and more. We've made some headway, but we do need to further our efforts in that way. Those are the issues that are near and dear to me. And, you know, I'm not just part of a coalition. These are my views. These are my campaign points. And I think they're very important to express them.
And I just wanted to talk about that last point there, because I know there's been talk about, you know, and certainly I can appreciate, you know, from the criminal defense perspective there, you know, the need for due process, right? And you know, the point of, well, what's happening, you know, if, you know, there's a recommendation that you say doesn't rise to that level of, you know, where there could be, you know, the lawyer or paralegal named of, you know, having to do some CPD or whatever retraining, but that's kind of publicly available without, you know, kind of going to a full hearing, as you point out. So how would you kind of balance, you know, trying to deal with those things so not everything goes to a hearing, kind of, you know, like you said, like an ADR process, or kind of maybe the equivalent of like a, you know, a Crown pretrial or something, but without the sort of the balance there, or finding the balance between protecting the public interest, but at the same time, you know, not unfairly naming and shaming this lawyer or paralegal without, you know, a proper course of action taking place.
Yeah, so I think, and I say this with a great respect here, relying on some of the misinformation that the Full Stop has been ranting about. And there's really, you know, two things I want to talk about. Let's talk about this proposal that is being considered by the Law Society. Right now, if the Law Society believes a lawyer has committed a disciplinary offense and the Proceeding Authorization Committee is satisfied that reasonable probable grounds exist to make out that offense, there's a few things that we can do. We can send the matter to a hearing. We can invite the lawyer to come in for a regulatory meeting, an invitation to attend, or a regulatory notice. A hearing's fairly obvious what that is. Those other three options only can take place if reasonable probable grounds to believe an offense has taken place. So it's not like if there's no grounds to believe an offense can take place, there's any suggestion that the powers of the Proceedings Authorization Committee be expanded. It's just not true. We don't authorize a regulatory meeting or an invitation to attend or a letter of advice without reasonable probable grounds to believe an offense is being committed. So that's the first point. So it's just not true that what they're saying that, that the Proceedings Authorization Committee is going to have this power and just to force things through. Many other regulators, as part of the regulatory process, can order as part of their regulatory meeting a lawyer to do certain things. We can't. We can have a meeting, regulatory meetings, a chat with three benchers where we talk about what they did wrong and try to help them so they don't come back. It's to a very large degree a restorative sort of process. The regulatory meeting gets public. We can't order that they take CPD. We can't order that they take some courses. It's just not true. The new proposal, which is not been passed yet, and I don't know if it will be passed, is premised on it's in a case other than a hearing, where a hearing could be ordered. Now, the things I'm talking about are way before it gets anywhere close to a hearing. If there is an issue, for example, that is some sort of what I'm going to say, a minor breach of the rules, those are the sort of things that I would love more and more. And the Law Society has done a fantastic job in the last couple of years of those sort of, informal diversions. Doesn't show up on the website, doesn't show up on the public register, doesn't show up anywhere, of making sure lawyers don't make mistakes. The practice of law is complicated. The law changes. People make mistakes. And that is what I'd like to see the discipline process do more and more of. And I'm confident that we can go down that route. It's clear if there was expansion of what they call the SCRPs, that's where PAC's power to make lawyers do different things. If that happened, again, it would start with reasonable probable grounds, and there would be due process. If that sort of thing took place, there'd be, it would be subject to judicial review. The Law Society often looks at things as a public regulator. They look at what other regulators do and see if it's a good idea or it's a bad idea. So I hope that answers your question. I hope it puts to rest the misinformation that has been out there. Misinformation from benchers is very troubling. And, you see it all the time on Twitter. Someone tweets something as a bencher and people believe it's true. It used to be, it was true. It used to be, JP, that if a bencher told you it was raining out, you didn't walk to the window. In the last 4 years, sadly, not only would you walk to the window, if you saw water, you might want to go outside and make sure someone's not standing there with a hose. And to me, that's a really sad thing that's happened.
Now, last couple of questions here. I know certainly you have many years of experience teaching trial advocacy, among other things. I think certainly if I go back, 15 years or so to law school, and I think there was like a mock trial of if it was suicide versus accident or something like that. I'm sure you've doled out plenty of advice to students over the years, but for those young lawyers and law students and paralegal students that are listening to this, any words of wisdom that you have for them?
Well, I can tell you, JP, in my trial advocacy course at Osgoode, we're no longer using Mary Dixon versus Prudential Life. I'm so happy you asked that question. I say, to young lawyers or newly called lawyers and newly entered paralegals, you're entering a fabulous profession. To me, it is one of the greatest profession there is. We're helping people every single day. As a criminal lawyer, no one's happy to be sitting in a criminal lawyer's office. No one's happy to be walking into a criminal court with a criminal lawyer, but we're helping people sometimes at their darkest day, and that's an awesome responsibility. If you are a sole practitioner, get a mentor. Lawyers want to help. Lawyers want to see lawyers do well. For example, as I said, the Criminal Lawyer Association, we started this mentoring program, which newly called lawyers are hooked up with a senior lawyer, they review their files, they help out. Lawyers want to be mentors. I can't tell you the number of calls that I get. I got a call about 3 months ago. It was a woman who I taught trial advocacy. She told me about 15 years ago at the intensive trial advocacy workshop, and she remembered my lecture on impeachment. I think it's the one I might have given to your students. She wanted the PowerPoint, and I was so happy to give it to her. And she asked if she could call me back to talk about it. We went through how to do an impeachment. She'd been out of practice for a little bit, and I spent a fair bit of time with her. To me, when lawyers reach out, I feel great. She asked me what she could do. She said, did I want to bill her for her time? I said, no, just pay it back. When a lawyer calls you up, you help them out. Lawyers love to help. The Law Sci has the Coach and Advisory Network, which is also one of the committees that I was involved in, where again, they'll hook you up with a mentor, even if you work in another firm. And there's going to be times, this is something I learned where I taught trial advocacy out in Alberta, in the Alberta Department of Justice. They have a mentoring system where a Crown can go to another Crown in a different office to ask that embarrassing question. Even if you're at a firm and you can find a mentor, get one. Most importantly, take care of yourself physically and mentally. Many of us, including myself, suffered mental health issues or suffered from mental health issues. I can tell you, during the pandemic, when I was, really locked down, I became terribly, terribly depressed. And I had to reach out for help, and I sought help, and it was not embarrassing to me. It was no more embarrassing to me than if I had, physically injured myself. It's going to happen to many lawyers. Justice Strathy spoke so eloquently about the challenges of mental health. We work in a high stress situation. No one would be ever embarrassed if they broke their leg and couldn't drive to court, calling up the Crown or calling up the judge's secretary and saying, I had this terrible accident, I can't come today. I can't wait till the day is that people feel the same way about mental health, the exact same way, because it's no different. If you got COVID, you wouldn't go to court. Why? You wouldn't be helping yourself. You wouldn't be helping anyone else. And I'm so happy that we are starting to recognize that. We are not infallible. The day of there was a death in a family and a judge said you got the day off, those days are long gone. If you don't take care of yourself and you show up to the court in that day that you just can't properly function, you're not helping yourself, you're not helping your recovery, and you're not helping your client. Lawyers will help. Colleagues will help. I will help. I can tell you, if there's anyone listening to this and they ever find themselves in that position when they wake up and they can't go to court, send me an email. I'll take care of it, because we are a profession. Criminal lawyers, we're like a family. And I suspect many other bars are like that. We have the Members Assistance Program, which is so important. It is a free program. It's funded by the Law Sci. Yes, it does cost money. Yes, some of your dues go to it. But it's such an important program that any lawyer, any law student, any paralegal, any member of their family can reach out. It's entirely confidential. It is only funded by the Law Society. It's independently run. They will assist. So take care of yourself. If there's one thing anyone's listened to me tonight, is take care of your mental health.
All right. So last question here for you and for any of the lawyers that are listening right now that have up to 40 votes in the election. Why should they vote for you?
Because I truly care about the profession. I've got way more yesterdays as a lawyer than tomorrow's. I think yes. And I care about the profession. I care about it. That's why I probably do more teaching than anything else. Someone said to me, why do you go to Calgary and teach the prosecutors for free? Because it's the same thing I want to do every time I teach a course, and I say to every student, I can't make you the greatest lawyer. We all can't be Eddie Greenspan, Sheila Blocks. But I want to help every lawyer be the best lawyer they can be. That is how committed I am to this profession. I am hardworking. I care about lawyers. I care about paralegals. And I am proud as today to say I'm a lawyer, as I was in March of 1989 when I put on my gown for the very first time. I'll work hard. I'll maintain self-regulation. And I listen to other lawyers. I know it's like when I got involved in family law and the FLSP, I reached out to the experts because I didn't agree with what was taking place. And I came up with an alternative proposal. I promise, like I have, if you ask any of my colleagues, probably even the people on the Stop Stop, they'll tell you I've always been one of the hardest working benchers there is. And I'll continue that. Again, I don't want to be a judge. I've never applied to be a judge. There's nothing in it for me. I've got no really skin in the game other than to help my colleagues, my lawyer colleagues, my paralegal colleagues, and my law students.
Perfect. So thanks once again for taking the time to speak with me, and thanks for everyone for tuning in. Take care.